Free them all?
We're saying,
Free 'em all, man.
Mumia
We got
Abu
rid of it.
Jamal,
Used to take
Oscar
these.
Grant,
Free 'em all. The positive energy is everything to us. So again, thank you guys. Appreciate it.
Thank you so much for having us. Thank you.
Thank you.
So Justice for Tyree, you guys see it here with the Nichols family and all the others that are out here fighting for justice. Okay, hey. Welcome back to the channel. I am your host, Hollywood Nex, and I am officially in the building. There I go. Okay, so I wanted to come on here to read the motion that was granted. But before I get started, you guys, hold on. I want my music louder than me. Before I get started, I must come on here and acknowledge one thing. I was incorrect, you guys, and I'm not perfect. Okay, I make mistakes, and I own up to my mistakes. That's why I specifically came on here with my face to be shown so I can stand on my business, okay, and my integrity. And when I'm wrong, I'm wrong, and when I am right, I'm right. 99% of the times I am right. I'll acknowledge that, okay? It's that 1% that just be like, ugh. It's almost like when you're reading your comments, you have all these positive comments coming in, and it's that one negative comment you just zoom in on it and you just want to address it. Well, anyway, that's what's happening now. So let me just get this out the way before I start my commentary. I want to say I was incorrect, and only thing I was incorrect about was that I felt that they was not going to recuse this particular judge. Glanville. I didn't think they was going to do it because, you know, the way everything is happening and all this accusations about the corruption and, you know, so I was like, well, if it's all this much corruption, I just didn't see a way out for him. I didn't think they were going to really let him go. But justice was served in that matter. Now, I was right about some other stuff, and we're going to get into all the details, but I just wanted to acknowledge that. Yeah, I just have to acknowledge that because that's what a real person who does commentary do. You stand up there and you own up to it. If I ever put any information out here that is incorrect, expect me to come on here and correct myself, okay? And the same thing goes with anything. And if you guys catch it, you email me and you say, hey, Hollywood, you know, I did a fact check. This is what it is. You were incorrect. I will still come back and stand on business and say, you know what? I was called out by a supporter, and this is what it is, and this is my error, and so I can move forward because I can't put information out here that's not accurate. I gave my opinion. My opinion was incorrect. That's what I'll say. It wasn't that I put out wrong information. It was more so my opinion. I gave that to you guys. I was like, I don't think they're going to let him go. Like, I was being real honest about that. But anyway, moving forward, you guys, let me just say, if you're new to this channel, I want to welcome you all. I am your host, Hollywood Nex, and boom. So if you see this, you know, this logo stuff right there, and then the logo on the hat, yeah, I'm repping my my gear today. So with that being said, I want to share my screen with y'all, and we're going to just get right into this. So thank you to everybody and appreciate the support that I'm getting behind the scenes. Shout out to Atlanta. Shout out to the A, because the A is supporting your girl. They are emailing me. They like, you know, turn your comments back on and this, that, and the other. One thing for sure and two for certain, I'm not going to do what I've done before in any of my previous cases that I follow. I ain't going to tip for tap with nobody. Ain't nobody fit to trick me up off the YouTube streets or anything like that. So if you feel a little froggish, go ahead and leap and jump for yourself. But I'm not going to go back and forth with anybody, and I'm going to leave that there, okay? And anybody that know me and been following me know I stand on business. I never was the type to do that anyway. I did it once, but shame on them. Okay, happens again, shame on me, and I will not be shamed. So here, let me pull up these here documents, and let's just get right into the reading. And I'm still gonna give y'all my opinion, right or wrong. Okay, I'm still gonna give y'all my honest opinion, and if I am wrong about any of my opinions, I will come back and make that correction, as I am doing right now. I'm standing on it because, you know, the right thing to do is to sit here and acknowledge when you are wrong. Everybody can't do that. Sorry for them, but kudos to me because I know where I come from. I know who I belong to. Anyway, so I got this document, and shout out to the people. They know who they is. I don't want to put my sources out there, but I do appreciate all the love and all the support that I get over here on this platform. So again, if you're new to this channel, welcome. If you're returning, welcome back. If you not subscribed, you like this commentary, you like the fact that I could come out here and put my face to being saying, oh, I was incorrect, or my opinion wasn't right, you know. I did put that out there, so I had to come back and stand on that. So you say, oh, I want to subscribe to her channel. Well, then this is the channel for you, okay? Straight up. And if you are subscribing, make sure you turn that post bell notification on and select all so you don't miss me when I come back and bring you guys yet another one, okay? So let's get right here into this here reading. The most is like 10 pages. That's nothing for a reader, okay? But if you're not a reader, you might want to go get a reader, or you might want to get an audio reader, or whatever reading you need to help you enhance your reading ability. But I would say go take a reading class. That's what I would suggest. I mean, because you always want to read yourself. You know, you don't want to be relying on these machines, because these things, they fall off. What are you going to do? I'm just saying. So, hey, girl, come on, Chrissy, come call me, and let's get right into it. I don't even want to start it without you because I see you in the chat. So let me get my co-host up here. I haven't been saying her name because I didn't know if she wanted her name to be put out here or whatever. But, girl, come on up here and co-host with me, and let's get this readings together. I've sent you the documents, so you should have them as well. Let me just shout the people out that is in my chat right quick before I get into this. And so if you guys want to be shouted out, make sure you're in the comment section, or you'll be missed out on getting your shout out, because the only thing I'll do after I'm done reading is see if there's any thing that I can answer or not, or my legal counsel, who is going to come up here, who has more legal background than me, because I am unofficially a lawyer, okay? I don't have the degree, but I do have criminal justice degree. But I did not continue to go as far as all the way up. So with that being said, shout out to my girl Spicy is in the building. Always my day one. Love, love, love you. Appreciate you for everything you do for the platform, as well as my girl Karen, my mod, okay? Appreciate you as well. And I see another day one in the building, which is Darlene. So shout out to you, boo. I appreciate you. We also got the official Dana J up in the building. The official, I'm going to say that again, the official Dana J is in the building, and no other than my co-host, if she call in and get on here, if she can. If she ain't available, it's fine. It's just 10 pages. I can read 5, she can read 5. If not, I'll just read all the way through and through. But at the end of the day, I appreciate you guys again, like I said, for tuning into this live and watching me stand on business and integrity, because I have integrity, I have morals, and I have values, and I respect everybody's opinion, whether you agree or you disagree. It's just the way we can do it around here. So now get into this here document. This is order on motions to recuse Judge Glanville. Hold on, let me go back because I went up too far. Hold on. Okay, so this is the order to recuse Judge Glanville. Why is I'm getting in this way, this format? I don't know. I went to my Google Docs, so it opened this way. This is the case before the court to consider various. Oh, and hold on. By the way, in Woody's voice, you fired. You fired. He fired. All right. So this is the case before the court considered various motions to recuse, including defendant DeMonte Kendrick's motion to recuse Chief Judge Oral Glanville, filed on June the 12th, 2024. Kendrick document 247. Kayla Bumpus, they put her in it, and she recently did her live, and she explained to her viewers about it. I got a clip of what I needed to get from her, her response, and I'll be sharing that momentarily with you guys. But anyway, Kayla Bumpus' motion to quash the show cause order and to recuse Judge Glanville's Adams docket 171, and the defendant Jeffrey Williams' motion to disqualify, recuse Judge Glanville from all further dealings in the above reference case, and amended supplement Williams docket 587-611. The specific facts to determine these recusal motions are well documented in affidavit I guess they're trying to say affidavits. It is affidavits. What am I talking about? They're trying to say it is affidavits. In the affidavits, courts filing, certified transcripts, and video recording available on YouTube. Having considered the record, evidence, and applicable case law, the court finds as follows. This court previously considered and denied the defendant's Kendrick's motion to disqualify Fulton County Superior Court judges from ruling on recusal motion Kendrick docket 260 and the portion of the defendant Williams amended supplement that sought this court's recusal. Let me blow this up because I'm just squinting my eyes knowing I can't see y'all. I'm sorry. I'm super blind. I promise y'all I ain't gonna say the next time, but soon y'all gonna see me with my glasses. I ain't gonna be able to do this. Let me see. Is the plus button? No. What did I just press? Lord have mercy. How do I zoom in? I don't know how to zoom in. I can't see. It's gonna be a squinchy situation, so it is what it is. It's a squinchy situation. I thought that would help me, but it didn't. All right, let me see. Okay, so I read all that. Okay, so the recusal motion to arise. Wait. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes, Kendrick docket 4. Although there were 28 defendants named in the indictment, only 6 were being tried as of June the 7th, 2024. The motion to recuse all arise from the same circumstances related to the state's witness, Kenneth Copeland. On June the 7th, 2024, the state intended to call Kenneth Copeland to testify prior to his testimony. Counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity ordered. Judge Glanville had entered that granted immunity. And Mr. Copeland, Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he said, "I plead the Fifth." Judge Glanville excused the jury, and Khalif Adams' case was severed. And though he is not currently on trial, his case was transferred to this court because Kayla Bumpus' motion to recuse Judge Glanville in association with the show cause and contempt issued was filed in Mr. Adams' portion of the docket, Adams docket 171. See certified transcripts of June 7, 2024, Williams docket 605. So on page 2 of 10, then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June the 10th, 2024, and which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Copeland. They would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated would revisit the issue with Mr. Copeland on Monday, June the 10th, 2024 at 8:30 in the morning, and court was adjourned for the day. On June the 10th, 2024, at approximately 9:10 in the morning, Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, which is Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial, defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Mrs. Love judged Glanville that Mrs. Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Mrs. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Mrs. Bumpus, Mrs. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville chambers where he spoke with and asked questions of Mrs. Bumpus. Judge Glanville and Simone Hilton, two investigators from the DA's office and multiple deputies were also present, as well as one or more members of Judge Glanville's staff, including his court reporter, who took down the conference. The certified transcript was filed into the record on July the 1st, 2024. Williams, docket 598. Counsel for the state, who had joined the meeting during that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibility after a grant of immunity. Mr. Copeland and his rights and responsibility after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Mrs. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, the defendant's Williams lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting and a lengthy excuse that word, occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Through Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams. Ultimately, Kenneth Copeland did testify on June the 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. Kendrick docket 245 and amended show cause order was later entered, setting July 1st, 2024 for an in-camera review of the transcripts of the ex parte meeting. The first motion to recuse followed by DeMonte Kendrick on June the 12th, 2024. Kendrick docket 247. Mr. Kendrick motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June the 14th, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review contains assertions of fact to support the allegations of bias and partially Adams docket 247, page 7. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting. The affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration, and that's ID. On June the 14th, 2024, Caleb Bumpus then filed a motion to squash the show cause order and or to recuse Judge Glanville from presiding. Hold on, I lost my place. Hold on, because y'all know I can't see. Where was I? Okay, right here. To quash the order and to recuse Judge Glanville from presiding over any contempt actions against Mrs. Bumpus resulting from alleged disclosure of the ex parte meeting. On June the 17th, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville Williams, docket 587, divorced from his From its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams' motion. Technically, Mr. Steele's counsel moved to recuse Judge Glanville from further handling of the contempt actions during the June 10th proceedings. However, that motion was made orally and it is not before the court because Mr. Steele's contempt matter is currently pending before the Supreme Court. Williams docket 614. Hold on, let me scroll this up. Okay. Right here. I think I just lost my thought because it was all though. Hold on. Mr. Steele matter. Da, 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 da. Okay, so alleges both actual. Wait. Where was I just at? Okay, so technically, Mr. Steele's counsel to recuse Judge Glanville for further handling of the contempt actions during. Wait, it must be up one more. Hold on. How did I just get that mixed up like that? Because I can't see. Let me get off the camera for a second because I can't see. It doesn't make sense to try to squinch my eyes for y'all when I can just zoom in and pull right on up to the front of this thing. Now I can see better. All right. So matter is currently pending before the Supreme Court. Okay. So alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer Brian Steele in contempt. And didn't I tell y'all that when he held Mr. Steele in contempt, I felt like he was showing his hood. Like he forgot he was a judge for a second. He took me to the A. I mean the deep dark parts of it at that. Anyway, so where was I just at? Okay, so he held him in contempt. On July the 1st, 2024, the day appointed for the parties to review a redacted transcripts of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcripts of the ex parte meeting and was taking judicial notice of in making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into surveillance's footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his review that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherited authority to hold such a meeting. See, and that's where he messed up at based on this reading, because he basically was responding to his own self and justifying his own actions when he should allow that to be justified for, a different judge or someone who's going to be looking at the these motions that was filed, especially the amended one. So anyway, let me see where was I. Okay, so Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned the defendant's right to be present at the ex parte meeting because the issue under discussions was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motion filed by Mr. Kendrick, Mr. Williams, and Mrs. Bumpus were being referred for considerations by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.7. The motion to recuse were then assigned to the court for consideration. Legal framework. So motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. USCR 25.1, 25.2. The affidavit must be definite and specific and describes circumstances of extrajudicial conduct or statements which demonstrates either bias in favor of any adverse parties or prejudice toward the moving party in particular, or a systematic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. USCR 25.2. Bare conclusions and opinions are not legally sufficient to support the motions or warrant further proceedings. ID. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assesses the timeliness and legal sufficiency of the affidavit and alleged facts. USCR 25.3. If all three criteria are met, i.e. the motion is timely supported by an affidavit and the facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. ID. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceedings in which their impartiality might reasonably be questioned. So what they're saying here is that he had no right to make a decision on the recusaling of himself. That should have been left to a different type of judge, according to the guided by Rule 2.11. Okay, now if I'm incorrect, correct me. Now, so the judges disqualifying themselves. Okay, should be questioned. Also, A&M Haas, or HOSPS, LLC versus Alamachandi 363 Georgia App 531-541-42 2022. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person rather than the affected judge or other interested parties. ID. If a motion to recuse satisfies the three thresholds criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. Monday versus Magnolia Advanced Materials Incorporated 303 Georgia 764-768 2018. The judge whose recusal is sought may not respond to the motion or attempt to recuse the allegations, which stands denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. Post versus State 298, Georgia 241, 244-45, 2015 law, okay? A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a basis for recusal. ID at 257, citing Isaac versus the state 257 Georgia 127-28 1987 ruled. Okay, a judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation, which he failed to do that. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality, and that's exactly what he did. One reason is that if he defends himself, which he did, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. ID at 258. See also A&M HOSPS, which is hospital, I'm sure for short. LLC 363 Georgia APP at 542-43, quoting post 298 Georgia at 257. See also Richard E. Flam judicial disqualification, recusal, and disqualification of judges, 15.7 at 435, second ED 2007 rule. A judge who personally refutes a party's allegation of judicial bias may appear to a reasonable person to have exhibited a personal interest in the outcome of the litigation, or to have aligned himself with the here Judge Glanville had previously announced on the record that the motions, hold on y'all, hold on y'all, let me get this, I don't know who this is. Hello? I gotta call you back. I gotta call you back. I'm live, honey. Okay. Sorry about that. So let me go back here. So the recusal and disqualification, y'all. So a judge who personally refutes a party's allegation of judicial bias may appear to a reasonable person to have exhibited a personal interest in the outcome of the litigation, meaning he kind of vested himself in this case. And this is just my opinion. This is not a fact, okay? So I want to make sure I separate my facts from my opinion. I got to be clear with my viewers here. So anyway, what he did was he kind of took it personal, this case, and he wants to see the outcome of this litigation may go against the truality, like, you know how people get railroaded and all these people get wrongfully convicted. That's what it's looking like, from the outsiders of like myself and others looking in. It's looking like, well, why is he still on this case? He's trying to sit here and he's holding the defense lawyers in contempt of court, threatening them on stand. You got 5 minutes to tell me where you got your information from, and if they didn't give it up, then they'll be in jail. Like you're bullying that was too personal for him. It did not make me feel comfortable when I was watching it, and I was just like, that's not cool. I actually wanted to do something like a short on it, but I never got around to doing it. But anyway, I constantly talk about it because it's just so highlighted. So anyway, the analysis and the discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit, so that was right, and transferring the cases to another judge for consideration. Judge Glanville necessarily determined, hold on, y'all, let me get this. This may be important. I'm live, so hurry up, baby. No. I tell y'all, they know I'll be live and they do that on purpose, but it's okay. That was family matters. So here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit, and transferring the case to another judge for consideration. Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized and the facts alleged in the motions were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting, let me pull this up. While the meeting could have and perhaps should have taken place in open court, nothing about the facts of the meeting or the substance discussed was inherently improper. So basically, they justified the ex parte meeting right there. So it wasn't anything, improper about it. It was okay, but it could have also been done in open court. It wasn't necessary to really do it behind the doors the way they did it, but that affected this decision, in my opinion. However, in his order denying the defendant Kendrick's motion and in the process of making his record on July the 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explain his decision and actions and argue why those actions were proper. And see, and that right there is why they went against him and recused him, because he judged the situation. He gave and I took my notes. Let me rely on my notes because I don't want to go off my notes. Okay, so let me see. What did I say about what he did? Well, we'll get into my notes. Let me just get to the reading. I'm almost done. So let me see. So while it was Okay, where was I at? Actions are argue why these actions were proper. Okay, while it may be appropriate for the judge to disclose information relevant to his potential recusal, to his let me pull this up. Inappropriate. Well, while it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is an as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate, which he was all of that, in my opinion, of course. Post 298, Georgia at 257, and presenting his record as to the recusal issue and in ruling on Kendrick's motion, Judge Glanville, party resisting the judge's disqualification and by attempting to refute a charge of bias, a judge may become or appear to have become an adversary of the party seeking his disqualification, evaluated and accepted the truth of his own factual allegations, mandating his recusal. A&M Hospital LLC, 363 Georgia at 542. This court has no doubt that Judge Glanville can and will continue presiding fairly over this matter if the recusal motion were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing the Judge Glanville from further handling of this here case. Based on the foregoing, this court hereby orders as follows. The defendant, DeMonte Kendrick's motion to recusal Chief Judge Oral Glanville is been granted. Caleb Bumpus' motion to quash the show cause order and or to recuse Judge Glanville has been denied as mute, meaning we'll get into that momentarily. Defendant Jeffrey Williams' motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of court shall reassign this case using the court's case assignments procedures. It is so ordered this 15th day of July 2024. Now I'll get back on the camera and let me push myself back because I'm so close because I can't see. Okay. And it's okay because I promise you I'm going to see clear one day. A little bit more clear. When I do, ooh, baby. So let me... Ooh, that was hard for me, y'all. I ain't gonna lie. I can't see. So anyway, let me get to my notes. So the outside Glanville judge recuses Judge Glanville in the ex parte. Was legal. They did say that was legal. What was illegal, the motion time, it was illegal motion time. Let me see. Let supported by the motion. Recusal might be warranted. Okay, so he argued the facts. This is where he went wrong at. Let me tell y'all what the judge went wrong at. He argued the facts, did not meet the threshold, added facts, provided context, questioned the veracity of the allegations, and explains his decision and actions and argued why the actions were proper. The judge is not an advocate witness, judge and jury to his own allegation. So that's why he was ultimately recused, because he pretty much he judged his case, he questioned the veracity of the allegations and explained his decision, which he was not supposed to do that, as we just read, and his actions, and they was argumentative. So that's looking like you are so biased in this matter, presiding over this case, when that's not your position. You're supposed to maintain your integrity. You're supposed to maintain, the integrity of the courts as well, okay? And the rules that you're supposed to follow. You have rules too as a judge. And he literally just looked at just bad. He looked at real bad, okay? That's my personal opinion. Y'all leave y'all opinion in the comment section. I would love to hear how y'all feel about the results of this judge. Do you think it was a good decision? I do. That's my personal opinion. What's yours? Now I want to get to my comment section so I can see any of y'all comments that y'all may have had or whatever. But I do appreciate you guys for tuning into this live or whatever. But I want to give y'all the clip of Mrs. Bumpus because she did a live shortly, and this is what she had to say about why they deny her as mute. Okay, let's see. There was the July 1st hearing, and at that hearing, Judge Glanville, he reads this judicial notice, and he goes through this timeline. And in that timeline, he includes the part about me being seen on camera talking to Attorney Steele, whoever I'm talking to, whatever. And so he goes through this long judicial notice, but at the end of the timeline, he says that he's not going to move forward with the show cause hearing, and he has no interest in doing so now or at a later date. But if anything, he would leave the matter up to the Supreme Court and the state bar. So at that time, one of my attorneys, Kristen Nove, she got up and she said, well, could you do an order on it? And he said, I'm not doing an order on it because, I'm just not moving forward. I don't need to do an order. And I think because there was no order done, that my motions kind of got compiled with the other motions filed related to the ex parte hearing. And when they got sent over to Judge Cross, even though Judge Glanville had decided not to move forward with the show cause hearing, there was no order. So it was essentially still an open matter. But if you read the order, it says that all the motions pertaining to me or filed on my behalf were deemed moot, which means no longer an issue. Basically. So I always knew that that's pretty much what would happen, that the order, as long as the order came out and deemed my issues moot, meaning no longer relevant, this isn't an issue, he did not move forward on that. So he did not move forward on that show cause hearing. So there really is no fight anymore because he did the right thing with that, and he went ahead and said he wasn't going to move forward on that. And that's that. So it's not an issue when they muted her. Even though in the paperwork it says denied as moot. Moot just means there's not an issue there. So they're not even concerned about that. Now, I was listening in to a lawyer, a real lawyer's platform, and there was a lot of questions that was coming in. See if I could pull it back up just to that 1 minute mark or whatever, because a lot of people was asking some of the questions that I was curious about as well. So like, what's going to happen next? So obviously there's going to be tons of motions that's going to come in because people are going to want to get this case thrown completely out, and rightfully so. But based on this lawyer, and this is just his own legal knowledge, not that this is what's going to happen in this case, because nobody knows what's going to happen until it actually happens, but people can put their predictions out there, what they feel could possibly happen. But he's a lawyer and he does this often. So trying to pull him up really quickly, but he basically said that by them recusing the judge, they're not gonna possibly, and this is his own opinion, of course, and this is, let me tell you, the lawyer, it's the lawyer, okay? He's so I want to go back to the question. Hold on, it's right here. Then the cases wouldn't be dismissed without prejudice, double jeopardy attaching, and not allowing them to retry. And this is fair act use.
Yeah, you're right when I say well-written order. What I meant was she knew what her end game was. She knew here's the decision I want to make. How do I get to this decision without offending everybody or causing a mistrial with prejudice so that it can't be tried again? So how do you do that? You absolve the prosecutor of any misconduct. Okay, that's clear. And then you absolve the judge of any misconduct in the ex parte order. And therefore, you have now those clean slates. Then you move to, all right, let's find a reason to recuse. All right, the reason to recuse, things that happened after the ex parte hearing. So again, she knew what her end game was. She just had to get there in a smart way.
Right. Anything else you want to say before you go? Because I know it's about...
No, that's it. I just think I said She did a good job of justifying where she wanted to get.
Exactly. Oh, last one here before you go. How will it be explained to the jury? They'll just say
they'll say something very neutral. Jury.
And see, that was the question too. A lot of people wanted to know. So, how are they going to tell this to the jury that judge is no longer on this case? That's because it's going to look real funny. You know, you got this new judge right here, Judge Ingram. Okay, and she looked like she stands on business. She looked like she has integrity. You know, and we just have to wait and see how things play out. But I don't know. Like I said, they're gonna try to push in a lot of motions to try to get this thrown out. The question is gonna be, will they throw this case out? That's what's gonna be lingering. But we have to see if those are if that are the motions that they're gonna file. I can only predict that that's one of the motions that they're gonna file. Try to get this whole case tossed out. And if they don't go for that, then I'm sure they're gonna try to at least try to get Thug a bail. Okay, he should be out. Like, this is ridiculous, because even when I go back and I'm looking at the opening statements and stuff, and I'm saying like, okay, so it seems like all this is about circumstantial evidence and he say, she say, and nobody that did the he say, she say actually wants to come up here and stand on it and go ahead and stand on business and basically get up on the stand and repeat what they had said in those statements when they was going in those police stations. Okay, so because of that, you know, I don't know, but I'm gonna get back into this little piece because he was asking more questions. There was
from
one
here
more
forward,
question.
this judge will take it. Judge Glanville is unable to proceed. You know, basically acting like maybe he had a heart attack or something.
Damn.
And do you think Steele will be able to call Glanville as a witness?
That's gonna be interesting.
I would try.
And so now that what they want to know is, because the defense, which is Brian Steele, which is right there next to Thug, okay, that he may want to call Judge Glanville as a witness. And so the question is, do you think he still will call him as a witness? And this is the response to that.
Sure, he's going to try to, Glanville, love all of them. But if he's able to get the same information in without calling Glanville, then they won't let him call Glanville. That's the point. Will Glanville be cumulative, or is he going to be new information to present to the jury? That's going to be the issue that's going to be raised.
Okay, so there you heard it. And I'll make sure I put the link in the description down below so you guys can go straight over there to the lawyer you know, okay? And that way you can hear his entire segment. I didn't want to take that man's copyright content, so I just gave y'all just a little bit of snippets or whatever, because, you know, I know the hate is real, but baby, it won't work around here because we are protected by the Most High. So let me see. Let me read your comment. So you say, yes, next. I was terrible. It was terrible. It was a good decision by the defense attorney to file the motion to recuse this judge. He was something else. He was pissing me off, and I'm just on the outside looking in. I'm like, dang, like they couldn't win a motion, they couldn't get this, they couldn't get that. Like, this judge was so vested to the point where he really wanted to stick it to Young Thug and the rest of these people. And it's like, you know, it's a right way to do things and there's a wrong way to do things. And if you guys follow the Alec Baldwin case, his trial, you saw that prosecutor knew nothing about the withheld evidence. And the moment she found out about the evidence, she tried to plead with the team, said, just dismiss this case. Let's just dismiss this case. That one prosecutor was not trying to dismiss this case, just like Judge Glanville did not want to be recused. He was going to stand on business all the way till a conviction was done. And that's not fair. It's a right way and there's a wrong way to do things. So in this matter, you know, he don't want to recuse himself. He didn't want to get off this case. And he was showing so much biasness that it was disgusting to watch. Okay. And then you also said, I was shocked about the arrest. Young Thug attorney held him in contempt of court. Now that was crazy. Yes. And I thought too, I was like, wait a minute, what's happening here? Because how is it that a judge is trying to hold this attorney that's representing his client in this federal case matter of RICO in contempt, all because he won't give up the information as to where he got his source. where he got the information from. He won't give up his source. And no lawyer is going to tell that where they got their information from unless they are on trial for something that they mandated to tell it. But in this matter, it just was weird to me. And he was threatening him literally in open court. Like, you know what? You got the X, Y, Z amount of times. It was like, what's wrong with this judge? He had a lot going on with him and it was not okay. And yes, I agree. Bye-bye to Judge Glanville, okay? The corruption was most definitely real. He just got himself so caught up in it. Now he got to look at the paperwork, and that's why I use that thumbnail right there, because he's on the panel, and he's looking at the document, and it's like, yeah, you just been recused, so keep looking at it, okay? I don't care how you look at it. It's recusal is all through there, okay? Sheila says, I heard by he is the chief judge. Yeah, at that. His hands is still on this case because all the judge have to report to him because he's the chief judge at this court. Now, that's a question I can't ask or answer. I mean, I can't answer, but that's a good question. I would ask the question like, can he still, because he is the chief judge, but I think he has nothing to do with this entire case, period. And I'm just going to stick myself out there a little bit on a limb and just say my opinion, of course, not a fact, but I would think common sense being recused, he can't see nothing that got anything to do with this case. I don't see him answering any other people pertaining to this particular case because he has been recused. So I think they was going to have to find additional judge, and that's just my opinion, not a fact. Let me put this out there because I know you hating ass people in the back want me to mess up somewhere along the lines and think that I won't come in here and stand on integrity and make my wrongs right, okay? But you sadly got the wrong one, okay? Because I stand on whatever I say. Now, I would just assume that they would do that. Have somebody else looking over this case, who they would report to as the chief judge, as not him. That's what I would assume. Now, my girl Spicy said pride, especially because it a high profile case. Yeah, it is a high profile case and everybody is watching. Everybody is reporting on this case and have been reporting on this case. So it is too much pride to dismiss the case. That's what he had. He had a whole bunch of pride, just like the prosecutor in the Alec Baldwin case. She had a lot of pride and she did not want to recuse herself. And in fact, she did something I have never seen done before, and she put herself on the stand. I said, is she really about to be a witness in Alec Baldwin's case? I mean, how close can you get? Okay. See, I don't mind to sit in the back and report. I don't got to run up to the courthouse and put myself all out there just to get a picture with this person and that person and say I'm in the business. I don't want to be in your business. Because the fact that we even talking about your business, I don't want to get close to that like that. And I see a lot of people do that. That's just distasteful. It's disgusting. And again, when you know better, you do better. And for me, I learned a lot of blueprint covering my very first and second trial, where now I know you'll figure it out one day. Is a lot of people put themselves in trials and cases and all this mess, but to each his own. Okay, I have a lot to say. I just haven't spoke yet, but try me and test me. I promise you, I'm coming back harder and stronger, baby, and it won't be the same as it was before. Everyone has a boss, including the chief attorney. Exactly. So I'm saying, so they won't report to that person. I believe they're going to go above him, and it's going to, they got somebody else to report to. It won't be him. He can't have nothing to do with this case. So I can't see anybody questioning him moving forward. But that's just my opinion, of course. I just can't see it. So I think that's it. Let me just see what else that I have for that, because that was really a short one because it was just 10 pages. Anybody going longer than they have to is just excited because they got some numbers to keep it rolling, keep the money coming in, okay? Because me, I stand on business. So let me just see. Yeah, that's pretty much it. And I've been dropping some short videos. I'll keep dropping my videos, and oh, I will say this. Let me say this in defense of Woody. Let me say this. Woody. Like, I guess you want to say Woody or whatever. Let me just say this. After my review, I still stand on business. Ain't nothing about to change about what I said in any of my videos that I put out there, except for whatever corrections I had to make in the beginning of this live. But I did read into the documents, and again, he was not the only person who was gonna be material witness. There were other material witnesses that's gonna, and it still has to come testify. And now we got to see how that plays itself out. But there's a lot of people who do not want to testify against Young Thug and has a change of heart. And clearly what I'm seeing is Wody has also done the same. You know, I'm thinking, looking at it the way I see it now from the outside looking in, and please, this is just my opinion, okay? I feel that, again, he was in his feelings back then. And then he may have just realized, well, Thug had nothing to do with this. The people who was, shooting up his mom's house, or, shooting at them and stuff like that, and caused him to come into fear, where he went into the police station. I believe he realized that it wasn't Thug. You know what I'm saying? It wasn't his order, is what I'll say, since they trying to put it out there like that. But I do believe that he realized it was not him. You know what I'm saying? And so, knowing what he knows now, he like, I can't send that man down. You know what I'm saying? I'm not fit to sit there and stand on this, but I get all the information that he put out here. I get that they was able to corroborate it all, but at the same time, he did have a change of heart. Now, you look at it how you want to look at it. Everybody's going to look at it different. We're all not going to see things the same. We can't do everything the same. One thing we can do the same is sing this together, but everything else we cannot. It was a lot of dirty tactics. I agree with you, Ms. Sheila. It was a lot of dirty tactics, but as far as him, like I said, he is an internet sensation. He is loved. He is favored out here. And he's living his life now. And hopefully, all this can be put behind him. There are additional questions that are, I'm curious about. Is he going to have to come back and testify now again? Or, because honestly, to me, I feel like he was forced to testify. His lawyer came in there and told the judge that he did not want to testify. He was going to go ahead and plead the fifth. And then the judge, with their dirty tactics, okay, with this judge with his dirty tactic, they went ahead and threw that immunity on him, and that immunity forced him to have to come and testify. And again, it wasn't the way they wanted him to testify, but he still had to get out there and testify. And I feel that was embarrassing. It was humiliating. It was degrading, and it put his life in jeopardy as well as in danger, because now, people are able to see the not even interrogation, but he was in an interrogating room. Not that he was being interrogated, but he was in that setting, and he gave investigators a lot of information, and that stuff would have never came out had this judge not immune him and forced him to come out here and testify just so they could release that information. So I think that was it was unfair. It was biased. And I'm glad that he is off this case. Okay, that's my thoughts on that. Get to the last couple of questions. If you guys have your questions, put it in the comment section. If not, we can talk about it down below. But the moment y'all get the coming from me, I'm shutting the comments off. I'm not even going to entertain y'all, because I'm favored by the Most High. God got me covered. So whatever, because I know who's behind it. I know the hate that's out here in these YouTube streets, and I get, they don't want me to talk about this case, but baby, you not stopping nothing. Somebody want to hear people who is intelligent, who have enough common sense, and who know how to read for themselves, okay? Not no audio machines. Like I said, I want that smoke with that person, and they know who they is. So it is what it is, but we can do it in decent and in order, and there's a right way to do it, and there's a wrong way to do it, okay? And I'm going to do it the right way, my way, not your way, okay? Because you ain't got them same millions you had. You might still got a few in your back pocket, but baby, like I said, it is what it is. Next, I did not want to bring this up or ask you, but okay. I did not want to ask you next. Do you think this is similar? Okay. As far as the similarities, I do look at it and I see some things with that New York trial, okay? Specifically the New York trial, because I always felt like the New York trial was a mock trial. I never thought that trial was real at all, because the way they, it was a hidden trial. Like, they didn't let cameras in there. You know, they didn't let people bring audios in there. We just had to rely on our handwritten notes, which I did that, and people wanted to, mimic me, but she can't. To be a copy ain't never gonna be worth the original. But yeah, it definitely has a lot of similarities. But like I said, that's what it is on that. I don't want to even talk about that. So that is not this, and that is out the picture. I don't discuss that case any further, and we just moving right on with the move along. Okay, we're going with the movement. Stay with the movement. Stay with the movement. And I get you guys want to ask me a lot of questions about the past cases that I've covered and all that stuff, but I'm just past that right now, and respectfully. Okay, I say that respectfully. So yeah, I mean, that's pretty much it. I mean, I don't think there's anything else I need to keep this live open for. It is what it is. If you're new to this channel, again, welcome. If you're returning, welcome back. If you haven't subscribed to this channel, go ahead and hit that subscribe button, turn that post bell notification on. Again, and like I said, and select all so you don't miss me when I bring you guys readings, okay? Updates as they become available. Take my little shots when I feel the need to, because I can, and ain't nobody gonna check me. They never have, and they never will. Okay, and I stand on it all. And yeah, so just make sure y'all subscribe to this growing channel. I appreciate you guys. We going all the way up. Okay, I see us on the road to 100K, but before we get to 100, we got to get to the 20s. Okay, let's show that we are mature. Okay, because we 18 right now, and I know we can get to 19 overnight if we just stay consistent. And then 20 is coming. So, and I'll be throwing out a lot of different commentaries. Like I said, I'm not getting stuck in the rut. And when this trial does start back up, what you're going to get from me when I get the documents is readings, also updates. I'll just be giving y'all updates and really my reaction. Okay, we're going to title it reactions because I want to react to this stuff more than I want to report on it. So it's reporting, but it's going to be reporting in action. So you're going to get a lot of show and tell. So that's what you guys can expect. Yes, you did right, and you did that. Ooh, okay, keep up the good work. Thank you, thank you, thank you. You know what I'm saying? So it's not like I'm about to fly to Atlanta. I'm not about to spend my money to fly out there and invest in place to stay. That trial is fit to go on forever. And if people got health issues and all that stuff, they need to be focusing on that more than they focusing on trying to be in the now. You know what I'm saying? Because a lot of people do things for the wrong reasons. And see, God sits high, he looks low. And I love the Lord because he always just he's just so good. I don't even have to do anything. And I learned how to not even really respond because the battle don't even be mine or yours. It be the Lord. So we should just let God do what he said he gonna do. Okay. Now that's it. That's all I have for y'all. I don't really have anything else on this here reading. So we're gonna get up out of here. But again, thank y'all for tuning into this live. Please hit the like button on your way out if you did not hit it on your way in. And I'll see y'all on the next one. That's my time. Peace.